Chapter 10. Examples from Statutes. In the following pages will be found a number of sections from statutes either conferring legislative powers on or providing for the exercise of judicial functions by ministers or government departments. The sections have been selected as illustrations of some of the different forms in which such statutory provisions are framed. The Patents, Designs and Trademarks Act 1883 gave wide powers to the Board of Trade to make rules for regulating the practice of registration under the Act, and generally for regulating the business of the Patent Office. It was provided that such rules should be of the same effect as if they were contained in the Act, and should be judicially noticed, but that they should be laid before both Houses of Parliament, and if either House, within 40 days after they had been so laid, resolved that such rules or any of them ought to be annulled, the same should, after the date of the resolution, be of no effect, without prejudice to the validity of anything done in the meantime under the rule or to the making of any new rules. It was these provisions which were in question in the case of the Institute of Patent Agents and Lockwood. By the Local Government Act 1888, the Local Government Board were empowered to make such orders as appeared to them necessary for bringing the Act into operation, and by any such order to modify the provisions of that or any other Act of Parliament so far as might appear to the Board necessary for that purpose. Section 7 of the Education Act 1902 provided that if any question arose under the section between a local education authority and the managers of a school not provided by the authority, the question should be determined by the Board of Education. The duties of the Board of Education in reference to the determination of questions under this provision were the subject of the decision in the case of the Board of Education versus Rice. The Trademarks Act 1905 gave power to the Board of Trade to make rules and prescribe forms for regulating the practice under the Act with respect to trademarks, and the Patents and Designs Act 1907 gave similar powers to the Board of Trade with respect to designs. Both of these acts contained the same kind of provisions as to the effect of the rules, and as to the annulment by the resolution of either House of Parliament as those in the Patents, Designs and Trademarks Act 1883 referred to above. The Small Holdings and Allotments Act 1908 made provision for the compulsory purchase or hiring of land by local authorities for the purposes of the Act by an order to be confirmed by the Board of Agriculture and Fisheries, and it provided that an order when so confirmed should become final and have effect as if enacted in the Act, and that the confirmation by the Board should be conclusive evidence that the requirements of the Act had been complied with, and that the order had been duly made and was within the powers of the Act. This latter provision, which effectively ousts the jurisdiction of the courts to inquire into the validity of any such order, has, as will be seen, found its way into many other statutes providing for the acquisition of land compulsorily. All questions of disputed compensation or rent to be paid for land compulsorily purchased or hired were to be determined by a single arbitrator or valuer appointed by the Board. The Housing, Town Planning, etc. Act 1909, by Section 17, provided for appeals to the Local Government Board against orders for the closing of dwelling houses made by local authorities, and by Section 39 the procedure on any such appeal was to be such as the Board might by rules determine, and the Board were empowered to make such order in the matter as they thought equitable, the order to be binding and conclusive on all parties, with a proviso that the Board should, if so directed by the High Court, state a case for the opinion of the Court on any question of law arising, and that the Board should not dismiss any appeal without having first held a public local inquiry. These provisions and the duties of the Board in reference to such appeals were considered in the case of the Local Government Board versus Arledge. The first schedule to this Act contains provisions for the compulsory purchase of land by local authorities which are in all respects, including the provision as to conclusive evidence, similar to those in the Small Holdings and Allotments Act 1908 above referred to, with the substitution of the Local Government Board for the Board of Agriculture and Fisheries. The Trade Boards Act 1918 gives power to the Minister of Labour by special order to extend or limit the scope of the Trade Boards Act 1909, an act for the regulation of wages in particular trades, every such special order without confirmation by Parliament to have effect as if enacted in the Act, but to be laid before Parliament and to be subject to annulment on the presentation of an address to His Majesty by either House. Before any such order is made, the draft order must be published and a public inquiry be held by a person not in the employment of any government department, who is to report to the Minister on the draft order. The Education Act 1918 provides for the compulsory purchase of land by local education authorities, and for this purpose incorporates the provisions of the first schedule to the Housing, Town Planning, etc. Act 1909 above referred to, with the substitution of the Board of Education for the Local Government Board. Power is given to the Board of Agriculture and Fisheries by the Animals (Anaesthetics) Act 1919 to extend or vary the provisions of the Act by order, the draft of any such order to be published for a period of 3 months before the order is made, and the Board to consider any representations by persons interested. An order under the Act does not take effect until it has lain for 30 days on which the House has sat before each House of Parliament, and during that period is subject to annulment by resolution of either House. By the Electricity (Supply) Act 1919, the Electricity Commissioners are given power to formulate schemes for the improvement of the organisation for the supply of electricity in any district, and, after holding a local inquiry, to make an order giving effect to any such scheme and present it for confirmation to the Board of Trade, now the Ministry of Transport, who may confirm it with or without modification. When confirmed, the order must be laid before each House of Parliament and does not come into operation until it has been approved, with or without modification, by a resolution passed by each House, but when so approved, it has effect as if enacted in the Act. These provisions were considered by the Court of Appeal in the case of Rex and Electricity Commissioners, and a writ of prohibition was granted prohibiting the Commissioners from proceeding with the consideration of a scheme which the Court held to be ultra vires. The Gas Regulation Act 1920 empowers the Board of Trade by order to repeal any enactment requiring gas undertakers to supply gas of any particular illuminating or calorific value, and to modify any statutory or other provisions affecting the charges which may be made by the undertakers, any such order to have effect as if enacted in the Act. Orders made in pursuance of these provisions are not required to be laid before Parliament. Very wide powers to make regulations for carrying the Act into effect are given to the Minister of Labour by the Unemployment Insurance Act 1920. Such regulations have to be laid before Parliament and are liable to be annulled on the presentation of an address to His Majesty by either House within 20 days. Subject to this provision, they have effect as if enacted in the Act, and the requirements of Section 1 of the Rules Publication Act 1893, requiring notices to be given of a proposal to make regulations, are expressly dispensed with. The Act also gave a temporary power to the Minister, in case any difficulty arose in bringing the Act into operation, by order to do anything appearing to him necessary or expedient to bring the Act into operation, and by any such order to modify the provisions of the Act so far as might appear necessary or expedient for carrying the order into effect. The Roads Act 1920 provides, by Section 9, for an appeal to the Ministry of Transport against a refusal by the County Council to issue a general licence under the section to a manufacturer of or dealer in vehicles, the Minister having power, on such an appeal, to make any order he thinks just, and such order to be final and not subject to appeal to any court. The Minister also has power, under Section 10 of the Act, to suspend, modify, or determine the liability of any persons, whether by virtue of any act or otherwise, to pay any sum by way of mileage charges or other annual payments in respect of the use of any road by their vehicles. By Section 12, very wide powers of making regulations for carrying the Act into effect are given to the Minister, such regulations to be laid before Parliament and to be subject to annulment on an address to His Majesty within 21 days from either House. Failure to comply with any such regulation renders the offending party liable, on summary conviction, to a penalty of £20. By Section 14 of the Act, an appeal lies to the Minister against a refusal by any licensing authority to grant a licence to ply for hire with an omnibus, the Minister having power on such an appeal to make such order as he thinks fit, the order being final and not subject to appeal to any court. By the Celluloid and Cinematograph Film Act 1922, the Secretary of State has power by order to modify or add to the regulations set out in the first schedule to the Act. Orders under this Act are not required to be laid before Parliament. The Salmon and Freshwater Fisheries Act 1923 provides for the compulsory purchase or hiring by fishery boards of any fishery by an order confirmed by the Minister of Agriculture and Fisheries. Such an order, when so confirmed, becomes final and has effect as if enacted in the Act, and the confirmation by the Minister is conclusive evidence that the requirements of the Act have been complied with, and that the order has been duly made and is within the powers of the Act. Extensive powers of making regulations are given to the Minister of Transport by the London Traffic Act 1924. Section 10 provides for the making of regulations under 23 heads for the purpose of relieving congestion and facilitating traffic in and near London, and these regulations may provide for the suspension or modification of any provisions of any statutes, bylaws or regulations dealing with the same subject matter, and may provide for the imposition of fines, recoverable summarily, for breaches thereof, and the making of any regulations under this section is conclusive evidence that the requirements of the section have been complied with. The regulations must be laid before Parliament and may be annulled within 28 days on an address to His Majesty by either House. The Housing Act 1925, by sections 11 and 14, provides for appeals to the Ministry of Health against closing or demolition orders made by local authorities. As to these appeals, see the case of the Local Government Board and Arlage. By Section 40, subsection 5 of the Act, an order of the Minister confirming an improvement or reconstruction scheme, when made, has effect as if enacted in the Act. It is not required that such an order should be laid before Parliament. The third schedule of this Act provides for the compulsory purchase of land by local authorities for the purposes of Part 3 of the Act, i.e. for the provision of houses for the working classes. The provisions of this schedule are similar to those contained in the Small Holdings and Allotments Act 1907 above referred to. Under the Town Planning Act 1925, a town planning scheme, when approved by order of the Minister of Health, has effect as if it were enacted in the Act, and such an order is not required to be laid before Parliament. The third schedule of this Act also contains provisions for the compulsory purchase of land by local authorities similar to those contained in the Small Holdings and Allotments Act 1907. Section 67 of the Rating and Valuation Act 1925 provided that if any difficulty arose in bringing into operation any of the provisions of the Act, the Minister of Health might by order remove the difficulty and do anything which appeared to him necessary for bringing such provisions into operation, and any such order might modify the provisions of the Act so far as might appear necessary or expedient for carrying the order into effect. The powers given by this section expired on the 31st of March 1929. The Fertilisers and Feeding Stuffs Act 1926 empowers the Minister of Agriculture and Fisheries and the Board of Agriculture for Scotland jointly to make regulations generally for carrying the Act into operation, and such regulations may vary any of the schedules and thus extend or limit the scope of the Act. The regulations have to be laid before Parliament and are subject to annulment on an address to His Majesty from either House within 21 days. Section 211 of the Poor Law Act 1927 gives very extensive powers to the Minister of Health to make such rules, orders and regulations as he thinks fit for the management of the poor, the government of workhouses, etc., 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 and generally for carrying the Act into execution in all respects. All rules, orders and regulations made by the Minister under these powers have effect as if enacted in the Act, subject to the power of the Minister to suspend, alter or rescind any such rule, order or regulation. There is no provision requiring that any of such rules, orders or regulations should be laid before Parliament. The Road Transport Lighting Act 1927 gives power to the Ministry of Transport by regulations to add to or vary the requirements of the Act. Such regulations are required to be laid before Parliament and are subject to annulment on an address to His Majesty from either House within 28 days. Patents, Designs and Trademarks Act 1883, 46 and 47, Victoria C. 57. Section 101, subsection 1, the Board of Trade may from time to time make such general rules and do such things as they think expedient, subject to the provisions of this Act. A. For regulating the practice of registration under this Act. B. For classifying goods for the purposes of designs and trademarks. C. For making or requiring duplicates of specifications, amendments, drawings, and other documents. D. For securing and regulating the publishing and selling of copies at such prices and in such manner as the Board of Trade think fit, of specifications, drawings, amendments, and other documents. E. For securing and regulating the making, printing, publishing, and selling of indexes to and abridgments of specifications and other documents in the Patent Office, and providing for the inspection of indexes and abridgments and other documents. F. For regulating, with the approval of the Treasury, the presentation of copies of Patent Office publications to patentees and to public authorities, bodies and institutions at home and abroad. G. Generally for regulating the business of the Patent Office and all things by this Act placed under the direction or control of the Comptroller or of the Board of Trade. 2. Any of the forms in the first schedule to this Act may be altered or amended by rules made by the Board as aforesaid. 3. General rules may be made under this section at any time after the passing of this Act, but not so as to take effect before the commencement of this Act, and shall, subject as hereinafter mentioned, be of the same effect as if they were contained in this Act, and shall be judicially noticed. 4. Any rules made in pursuance of this section shall be laid before both Houses of Parliament, if Parliament be in session at the time of making thereof, or, if not, then as soon as practicable after the beginning of the next session of Parliament, and they shall also be advertised twice in the official journal to be issued by the Comptroller. 5. If either House of Parliament, within the next 40 days after any rules have been so laid before such House, resolves that such rules or any of them ought to be annulled, the same shall after the date of such resolution be of no effect, without prejudice to the validity of anything done in the meantime under such rules or rule, or to the making of any new rules or rule. Local Government Act 1888, 51 and 52, Victoria C. 41, Section 108, subsection 1. If from any cause there is no returning officer able to act in any county at the first election of a county council, or no register of electors properly made up, or no proper election takes place, or an election of an insufficient number of persons takes place, or any difficulty arises as respects the holding of the first election of county councillors, or as to the first meeting of a provisional council, the local government board may by order appoint a returning officer or other officer, and do any matter of thing which appears to them necessary for the proper holding of the first election, and for the proper holding of the first meeting of the provisional council, and may, if it appears to them necessary, direct a new election to be held, and fix the dates requisite for such new election. Any such order may modify the provisions of this Act, and the enactments applied by this Act so far as may appear to the Board necessary for the proper holding of the first election and the first meeting of the provisional council. 3. The local government board, on the application of a county council or provisional council, may within 6 months after the day fixed for the first election of the councillors of such council, from time to time, make such orders as appear to them necessary for bringing this Act into full operation as respects the Council so applying, and such orders may modify any enactment in this or any other Act, whether general or local and personal, so far as may appear to the Board necessary for the said purpose.